Sorry, morning, Chief Justice.
What are your qualifications?
Chief Justice, I have a BCom, an LLB, and an LLM.
Yeah. What was your area of specialization at LLM level?
Well, currently, I think I said 40% constitutional law and administrative law, and about the same commercial law and insolvency. And when I started at the bar, of course, also criminal trials. I was an attorney previously.
But it's okay. No, carry on.
Well, during the time of an attorney, of course, I was then a junior attorney. It was a very wide selection of work at the bar, which is now, this will be my 27th year at the bar. The work has more progressed to civil work, commercial work, civil litigation, which then includes appeals, trial work, and opposed motions.
Have you had a fairly busy practice?
Yes, Chief Justice, I've been fortunate.
And for how long in all have you acted as a judge?
Chief Justice, I tried to ascertain the specific dates
Yes.
of the years. The initial years was unable to do so. I was awarded silk in 2006.
Yes.
I started acting at that time, not started acting, but from then on did acting stints. Initially then as part of the collaboration between our bar and our judge president, the senior members of the bar assisted in dealing or assisting with a backlog of criminal appeals, and I started doing those appeals. Those were pro bono acting stints. I seen one of the comments of one of the parties who might have made a more accurate calculation. They estimated about 16 months. I think that might be an over-exaggeration. I think it might be closer to 14 months if one adds all the different terms.
Yes. And how did you find your act instinct?
Chief Justice, in our division, as you would know, that's particularly Pretoria, is the busiest division in the country, which means that of all the roles, be it appeals, trials, unopposed motions, or opposed motions, they are very congested and very busy. So it puts pressure on a judicial officer to timeously perform the work and render judgments. I've always and all the times diligently tried to do so. I don't have any outstanding or reserved judgments. I've compiled a list previously of my judgments, and I haven't calculated, but I think on average, even if it's reserved, the period of reservation would be a month or less. So I found it challenging but enjoyable, and I believe I've discharged my duties at every time when I acted.
Let me just ask you a question that I might not ask other candidates, just to take advantage of your presence here. I daringly agreed to a 2-hour radio interview recently, and one of the practitioners in Pretoria called me, and this was the complaint. Papers are often in Afrikaans. I have to charge my clients more because it takes me longer as a person who doesn't understand Afrikaans to grasp the message communicated through those papers. Can't anything be done to use English as the language of record? And of course told him that as heads of courts we passed a resolution that English will be the language of record. What do you think could be done to encourage everybody to use the language that we know almost all practitioners understand?
Yes, I agree, Chief Justice. Well, if English is not the first language, at least it is a reasonably common second language to all the practitioners. And if that principle relates then to practicality, to speed, to easier access and usage of it, then it should be enforced. There are judgments which say that a person is, of course, entitled to his language of choice, even in his litigation, but then he should have the obligation, I think, to have his papers then translated for the benefit of the others who does not have that particular language as their first language. And it should be universal. I think I've gone through my judgments, or some of those again last night, and I see that I often start a judgment to say, well, the papers were in Afrikaans, but the argument was in English, and then I proceed with the judgment in English. Or even if some of the papers were in Afrikaans, I then proceed to render the judgment in English, so that it is more readily accessible and understood to all the others. And I think that should be the principle.
And how do you handle it sensitively in a manner that does not suggest to those who are passionate about the use of Afrikaans that there is some kind of an onslaught against their language? What would you suggest? How do you bring them on board for the sake of the speedy finalization of cases without antagonizing them unduly, in other words?
Well, as a litigant and as they utilize the court, they should also realize that the court is not only there for them in that particular case, but for others. And then they should understand that if any others want to find out what happened in their case, or even if it is a case of a principle and others might want to rely thereon, then as a litigant, they should then accede to, even having used their own language, that the judgment or the dealing of the case is in such a manner that it also benefits other users of the same court, the same access to justice rights. But having said that, Chief Justice,
yes,
I suppose that'll apply to all languages. It should not only apply to Afrikaans. Even those who do not have English as a first language, or not even Afrikaans as a remote language, should also be treated with the same sensitivity to know that in courts, to make it practical, we are doing it in English. It does not mean we demean or detract anything from your choice, but that is how it works practically best for everyone.
Well, to the best of my recollection, only once or twice did a practitioner use Sepedi in court, and once isiXhosa in court or in his pleadings, but otherwise people have generally been using English.
Yes, Chief Justice, but that doesn't mean that they are not sensitive to their language. They accede to using the English.
Everybody loves their language, yes. JP?
Thank you, CJ. Good morning, Advocate Davis.
Good morning, JP.
The spreadsheet I've got in front of you, I think it's on the left. I don't know, you have it.
Yes, thank you, JP.
It depicts what I could pick up as the work areas you've been deployed to when you were acting.
Yes, JP, except the references, JP, in recess.
That's the early part of your acting
Yes.
stints, the pro bono
Yes.
acting stints.
I see, JP.
I was not JP at the time, but I
is-
tried to go into the records. I hope that accurately reflects the pro bono work you say you did.
Yes, not all of the first terms where it depicts recess were pro bono. Some were not.
Okay. Okay, but it roughly depicts what you've done,
Yes.
at least since I've been JP, from 2012 onwards.
Yes, JP, I believe it does.
Now, you say in your application you do a fair amount of appearances. In fact, that's the predominant part of your practice, to appear in court.
Yes, chamber work, being pleadings and rendering opinions, also constitute a part of practice, but a lesser part.
Yeah. You do a fair amount of drafting in terms of heads and pleadings, as you say.
Yes.
Did that come in handy when you came to act and write judgments?
Yes. When one drafts heads of argument, it is to present a court not only with an argument, but also to say to a court, this is my client's case, these are the facts, this is the law, this is how it should be treated, and in the end, this is what the judgment should be, because this is the order my client seeks. In dealing with the judgment, it also does the same, except it has to marry two competing sets of similar contentions. But it does assist.
You've done a fair amount of work in the unopposed court and the opposed court, and I see you also have a week in the urgent court.
I think I had 2 weeks in the urgent court. There was a surprise. One was an allocation which I wouldn't have been there, and there was a late change in in the roster, and I ended up with a surprise second week in the urgent court. I think that was in maybe it's been Johannesburg. But yes, JP, I've roughly had a look at the unopposed motion court roles, and I counted that I had presided over 23 roles, which in our division, as you would know, equates to between 50 or 60 matters per role, which equates then to something over 1,300 applications.
Yes.
Only the unopposed matters.
Yes. Now, which of these courts do you regard as the most difficult? Unopposed, opposed, civil trial, special civil trial, third court, urgent court, appeals?
JP, they each present individual challenges. The unopposed motion court in our division, and to some extent in Johannesburg as well, poses the challenge of dealing with a large volume of matters in a reasonably short time. Although one has a reading day prior to the day of hearing, one must really read carefully, diligently, and at some speed to go through all the applications to know as much as each of the individual counsels do. That's the unopposed challenge. And then a ready knowledge of the law applicable. The opposed motion court, one has more time and one has the benefit of heads of argument, but it is challenging in the sense of opposed contentions, sometimes on intricate issues of law, but then one has a bit more time to deal with them. Appeals, one has the benefit of the record, and two judges or more judges work together thereon, so that almost is a benefit, although it is already sitting in appeal on another judicial officer's decision. Civil trials are almost, in my mind, the easiest because there is less of a pressure, there is less of a time constraint, and the matter develops as the witnesses present themselves and as the cases do. And one can still also, at the end thereof, call for heads of argument, written heads if counsel do not sufficiently address the argument. So those are the challenges I experienced in respect of each of the different branches of those applications. Urgent applications, of course, constitute almost a mixture of all four, and has its own pressures. But urgent court, one must just handle as the matters come before you.
Okay. Coming to the list of judgments that you've provided, it provides a very varied exposure to areas of law in which you were called upon to write.
Yes, JP.
Yeah. Any comment about that? About the areas in which you've written judgments. Has it prepared you for permanent judicial appointment?
Yes, JP, I believe it does. One should not be presumptuous to say every time that you act it is easier, but every time that you act you have the benefit of prior experience. And of course, the wider the experience, the better the benefit.
Yeah.
So each of those are the areas, and I dealt with them, I think, in the list from current to the oldest, I think reflects two things. I think it reflects firstly the variety of cases generally in courts and generally in our division, and secondly it reflects the variety of matters upon which a judge is called upon to adjudicate, and then if he applies his mind, he can, and as he should do, give a judgment in different areas, and not only deal with matters which sometimes appear to happen procedurally by postponements, etc. There should be a merit judgment.
Okay. I've counted a total of 112 judgments that you've written. I've just excluded the unopposed motion court weeks that you've reflected in your spreadsheet. Would that roughly accord with your own records?
Yes,
112.
JP. Yes, JP. These are, I think, 132, which I've extracted from my bench books.
Yes.
I went back to my bench books, and from those that my secretary have been able to produce, which she had typed, and from those written in my bench books and my notes, these were the judgments I could extract therefrom, yes.
Thank you, Advocate Davis. Thank you, CJ.
Thank you, JP. MEC.
Thank you so much, Honorable Chair. Hi, Advocate Davis.
Good morning, Commissioner.
I can see you have listed the case of the late Hendrik Nyati and MEC for Health in Gauteng. as one of the cases that, according to you, changed how state organs need to respond to some of the judgment that the bench passes.
Yes.
And you specifically indicated the issue of state liability. And in this matter, unfortunately, by the time the case reached the Constitutional Court, the applicant died.
Yes, he
And,
passed away since.
He passed away. Is this, is it something that you feel that needs to be attended where justice is delayed or the wheels of justice grind slowly to such an extent that people that intend to benefit out of judgment of courts unfortunately even die before they receive any benefits?
Yes, Commissioner, unfortunately, that appears not to be an isolated case. In my judgment, which went to the Constitutional Court, I relied on judgments in various other divisions, particularly the Eastern Cape, where similar kinds of hardship were experienced by citizens who were entitled to even welfare or disability or pension payments. And the delays in, as you say, the wheels of government prejudice them. And if they were then to come to court and say, well, I want to enforce it, and it even then takes so long to enforce it that the hardship is increased, not necessarily to the extent of the late Mr. Nyati, but any hardship, then it is something which needs to be addressed. It makes a government and us all even more accountable if we cannot, through our own processes, protect the most vulnerable.
My interest, what made you to leave the law fraternity? I mean, you were a candidate at in 1985 and decided to join the army as a national serviceman or a lieutenant.
I'm sorry, Commissioner, I had no choice in that.
It was conscription at that time?
Yes.
Okay. Thank you so much.
Thank you, MSc. Commissioner Ndoni.
Thank you, Chief Justice. Good morning, Mr. Davis.
Good morning, Commissioner.
Yes. In your letter of nomination from the AFT, they indicate that in your capacity as the chair, you initiated a meeting with the State Attorney Pretoria to raise two issues. One, the briefing patterns, and secondly, the late payment of fees for the black juniors.
Yes.
When was that?
Just as I've tried to, since last year when I was deputy chair, to initiate that, as we couldn't get sufficient written responses. The meeting referred to in the AFT nomination was in March of this year.
Have you seen any progress on the matters that you raised with the state attorney? Has there been an improvement in the briefing patterns or in the late payment of the fees?
Justice, unfortunately not. Or if there is any progress, it is too little to be visible. Yesterday, before even coming here, two black female juniors of 1 year standing came into my office to say, please, can you do something about the following? And their complaints were exactly the same as those posed by me and by the Bar Council. I cannot claim sole credit or responsibility for it, to the State Attorney in March of this year. I've also had very unsatisfactory responses to letters inquiring as to progress, as to implementation of briefing patterns, as to measures to pay particularly the Bar's juniors. And a meeting which would have happened this week has also been cancelled. So unfortunately my answer is I have not seen sufficient response.
Thank you, Chief Justice.
Thank you, Commissioner. Commissioner Nyambi.
Thank you, CJ. Morning.
Good morning, Commissioner.
Are you able to speak any African language?
Unfortunately, Commissioner, apart from greetings and picking up words when people speak, I am not fluent in any African language.
Are you involved in any attempts to improve with regard to that?
Yes. Every time when I meet my colleagues or when they have their own separate meetings or the AFT and they start talking, then they start switching to English, but I'd like them to carry on and I try to pick up. I've also acquired language courses, but I must confess practice intervenes and I am not fluent in any of them yet.
How can language, race, and gender legitimize confidence in the judiciary?
Sorry, how can language, race, and gender legitimize confidence in the judiciary?
Yes.
Well, if one were to look at our history and one were to have a single race, single language judiciary, then virtually everyone else who appears before such a bench might say, how can I be sure I'm going to get a fair trial? The person doesn't know me, my language, or my culture. The more diverse the judiciary is, the more the perception, and perhaps more than a perception, the reality of a broader consideration of issues appear. And the more anyone who can then appear can say, but I have now more confidence in the judiciary, that should relate to legitimacy. But on the other hand, if there is a representative judiciary, it should be legitimate in any event, and the manner in which it reaches its decisions and judgments should give it itself on merit legitimacy. Because the composition of the bench is not a guarantee that a Zulu person appearing for a Tswana might not have the same perceptions as a Venda person appearing before a white person. So, of course, a transformed judiciary, and that's why I often use the word transformation, does entail race and gender in its composition. But transformation should be more in the mind than only in that representativity. I hope I answered your question, Commissioner.
Thank you, CJ.
Thank you, Commissioner Nyambi. Commissioner Didiza.
Thank you very much, CJ. Good morning, Advocate.
Good morning, Commissioner.
In your questionnaire, I just want to pick up two issues. One that relates to an article that you regard as the most significant, which contributes to law, in your view. You didn't mention the article that it was in the RAS, but you didn't give us a short, motivation of what was the article about and what its contribution to law is.
I'm sorry, Commissioner, was that about a publication?
Yes.
Yes, that is when I started at the bar, well, shortly after I started at the bar, and I saw how practitioners at the bar dealt with, in that instance, expert witnesses, different from the experience which I had as an attorney. And the article was about leading expert witnesses. Subsequent to that, however, at our bar in particular, we have developed training in workshops which we do for pupils particularly, but also existing particulars in practitioners in dealing with expert witnesses, and we do those workshops annually. So I hadn't had an opportunity to carry on with that, but that was what the topic was about.
The second question relates to your contribution to transformation of the Pretoria Bar, which you cite in the questionnaire. If you can just briefly say, what were the challenges that relates to transformation that you had to confront in the Pretoria Bar?
Commissioner, primarily two. The first one was that the bar was historically, as was other institutions in South Africa, mostly white and mostly male. Both had to change. It is difficult to change an institution which is voluntary, where people of their own accord come. So what one had to do was to make it, and that is still the mission statement which I formulated, I think, 2 weeks ago for the bar, is to make it not only a service provider of choice to attorneys, but a place of practice of choice of practitioners. So one had to encourage people of color and more females as well to make the bar a career and the Pretoria Bar a place to practice. And we have, I would not say managed to do that, because transformation is a progressive, continuous progress. But for example, initially there was no requirement on race or gender when pupils were accepted. We've changed that to progress from both should be factors. We've changed that over the years to say, well, someone's at one stage, the proposition was that it should be 50-50, as we do with our co-governance with AFT. Together with, I think, Motimele Esi was then chair or deputy chair. Him and I changed that to say, but it should be not a 50-50, that should be the bare minimum of a 50%. We've increased that, I've done so in the past year, that was a proposition which was accepted by my bar council, to increase that to 60% of our pupils, which have then been admitted per year, to be then race composition. So not less than 60% of our pupils, not 60% of our pupils are then traditionally black. And then we add above that then the gender qualification. The position is to move that up to at least 75% within the next year. That is the one challenge meeting that is starting the bottom of the bar, the junior, where people come to the bar. So the one transformation challenge was to change the bar as itself. The other challenge is, because we're a referral profession, is to change those who give us work, or those who give the advocates work. And then we had to, one has to do the difficult thing to change the minds of those who give the bar work to say, give it in a different manner. And that's how we get to briefing patterns. And that's how I get to talking to the state attorney to say, you as a state institution are doing two things. You're prejudicing my transformation program, or the bar's transformation program, and those where we have transferred and we have new black juniors, for example, you don't pay them, and then they can't pay their own bills, and thereby you again prejudice transformation. So those were the two challenges that we had to meet, in which my bar council and the bar council, if I'm appointed, I'll leave behind, are to progress on that path.
Just the last question, CJ. On the gender dimension, I hear you have put together race and gender minimum 60%. But from a gender perspective, what would you say had been the challenges in terms of your transformation within the bar?
There are, again, more than one. Female or gender transformation had been easier in the pupillage stage and the junior stage. But then, unfortunately, the retention of female advocates is a difficult thing to do, because of own personal reasons or family or otherwise, they leave the bar. The other more difficult thing is, of those who remain at the bar, it's difficult to get them to apply for and progress for silk applications or senior status. I've been asked about this before by various people, but I can't force, unfortunately, women to apply for silk. And then it leads the bar, unfortunately, with a low percentage of female silk or senior practitioners. I talk to the female practitioners on a daily basis, and I think now our exhorting them to do so have paid off to an extent, because in the next month there will be the consideration of the applications for silk for next year, and I think, on a rough estimate, if I can't recall correctly, the applications are closer to 50-50 on gender than ever before.
Thank you.
Acting President.
Thank you, Chief Justice. Good morning, Mr. Adams.
Good morning, Davis, Justice.
Did I say Adams? Sorry, Mr. Davis. I'm very sorry. I see that your practice has been quite diverse, but you do not appear to have any experience in criminal law, and it does just hear me out. It does not appear that you have done any work in that area in the High Court as well. Now, I raise this question with you because it's a big concern for me. As you know, criminal law is an important component of the court's work, which all judges are expected to do. And I think in our push to get judges who are proficient in commercial law, in shipping law, in these, I would say, sexy areas of the law, the criminal law component often gets overlooked. Now, the concern is this: in those cases, you have this eminent Silk, for example, who's now a judge, who was an expert in shipping law, who did not do any criminal work at all. And you have these vulnerable litigants who are often represented by lawyers from the Legal Aid Board, pardon me, JP Mlambo, who more often than not don't have much experience either. And at the end of the day, you find judgments that show that the judge did not have the very fundamental principles of this area of the law, and they give bad judgments to the prejudice of the litigants. So that's why I'm raising this with you. Do you think your seeming lack of experience in this area might disadvantage you when you are presented with that kind of work, if appointed?
Justice, firstly, it is only seemingly so. One of the first reported judgments that I appeared in was a criminal matter. When I started practice, apart from trials, during the phase when the Criminal Procedure Act was amended, and thereafter during the interim constitution, I was fortunate to appear in your court on 13 occasions in criminal matters. I have since not been in a reported criminal case, but I have done criminal work, and on the stints that I've acted, initially I started even helping with a backlog on criminal appeals. I've counted roughly, I think I've given 32 judgments in criminal matters. One of them included in my bundle was a judgment of a full bench, where I wrote the judgment and the other two judges agreed, which was also a criminal matter. It's the one of Motau, which is in the bundle. Apart from the criminal appeals and the criminal judgments, one also deals with, in High Court Division, with reviews of criminal cases, and then bail applications or urgent bail applications or bail appeals regularly. I think in my list of judgments, I think there are at least 2 bail application judgments as well. So firstly, I don't think it is that much of a lack. I might also mention, it now occurs to me, or I recall that during the time that I acted or appeared in the SCA on those 13 matters, I was also busy with my master's degree, and one of the sections required a choice small thesis, and I did mine on the death penalty as it then occurred. So I had exposure to criminal work, both as an attorney and as a counsel. I've acted in trials. I've been reported in at least once in a criminal matter, and I've been dealing with criminal matters then at least on the appeal or review position as a judge. So I do not think that I have any lack or understanding. I have not, in the matters that I've dealt with, feel hampered. And when, as you know, when 2 judges or 3 even sit together on an appeal, and in our division say there's a roll of 6 criminal appeals per day, and you have 3 of those days in a week, between the 2 of you, you debate the matters and the issues, and in our debate, I've never, or debates with various other sitting judges, never, without being presumptuous, realized I have a shortage in my experience or my lack of understanding of criminal law or criminal procedural law.
I'm satisfied, Mr. Davis. I
Thank
nearly
you,
called you
Justice.
Adams again. Thank you.
I'm not sure
Thank you,
which
CJ.
of us should be more upset, Mr. Adams or myself.
Commissioner Malema.
Thank you very much. Morning.
Good morning, Commissioner.
I heard the answer you gave on the military, that you had no choice.
Yes.
You want to stick to that answer, that you didn't have a choice.
But it was the law at the time.
But you want to stick to the answer that you didn't have a choice. You didn't have a choice. Is that the answer?
Well, apart from being a conscientious objector and then refusing or then leaving the country, I believe at the time I didn't have a choice but to comply with the law.
But you had the chance. We had the chance. You had an option to defy the unjust law. You didn't have a chance. You had a chance. You had an option to defy that unjust law like many others did. Why didn't you do that?
I perceived at the time that the law, if it is then to assist the country in protecting itself, was that portion of the law that I could align myself with, and I did not otherwise deem that part of the law so unjust to refuse.
You perceived at the time that it was a correct law. Was it a correct law?
It was a correct law in the sense of getting a military force to protect the country. It was an unjust law in the way in which the law operated and in which it was part of the machinery of the state at the time. It was unjust in how we went outside our borders and committed all the things that was ordered to do.
Was it the correct law?
In that sense, then, Commissioner, no.
No, but you gave me two answers earlier on. I want to know if that law was a correct law. Was it the correct law? Why did you comply with it? The reason you complied with it is because it was a correct law, right?
Commissioner, with respect, I said the law was correct insofar as it enabled a state to have a military force to protect itself. Its application in how that was utilized was incorrect.
I'm not asking the question whether it was applied correctly. So you are answering a question which was not asked. My question was the law correct?
As a general application, the law in itself, yes.
Can we do the same law today?
No. We can't.
Why? Because it is the same law, it's a correct law. It can't be correct in 1985 and wrong in 2016.
Because we've seen how that law was incorrectly applied. There is still the law comprising of the military which defends the country. It does not currently, though, however, contain a prescription of certain other citizens, and it does not currently allow those citizens to enforce an unjust mechanism of state.
You have conducted a very good interview. You are just about to mess it up now. And I regret why I came in, because I should have just kept quiet. Maybe I would have saved you. But since we're here, let's canvass this point. I'm still saying to you, I'm not talking about the application of the law. Was the law right? I will come to the application. And your answer is yes, the law was right. Because it was a correct law, can we still pursue the same law today, since it was correct? And then we subject your son to the same law? Can we do that?
No, we can't.
Why? Because the law was not correct. It was a bad law. Do you agree now? People must have a choice. They must not be forced into the military. They must choose to join the military.
That is correct, Commissioner.
So it was a wrong law. Do you agree? It was not correct.
Yes, Commissioner, I agree.
Now, why did you comply with a wrong law? When you had a choice to defy, take an AK-47 and defy the unjust law, why didn't you do it? Madiba has done it. Slovo has done it. Ronnie Casares has done it. Why didn't you do it?
Commissioner, you can still put your question. Candidates are often intimidated before they even come in. Just put your question, please. Don't raise your voice, please.
I'm not fighting, CJ. We speak differently, all of us.
I understand, but
Yes.
It may not register that way to a candidate who's only here to put his point across. The more forceful the voice, the more intimidated many candidates tend to be. And I would be failing if my duty if I don't intervene, because it's going to look like I'm not protecting the candidate. The next thing, he doesn't perform in circumstances where, with a more moderate voice, he would possibly have performed. That's all I'm appealing for.
CJ, I don't have a moderate voice. That's who I am. You are asking me to be something I'm not. You are asking me to be something I'm not. And I'm not doing this with this candidate, unless there's something special about this candidate. That's how I've conducted myself since I arrived here.
Okay, well,
I don't have a moderate voice. I don't know what moderate means.
well, put your point.
I've asked a
across.
question.
Yes.
Commissioner, the portion of the law which then required someone to do his duty to protect his country was what I responded to. I did not, at that time, perceive it to be necessary to break the law, to take up the arms which you mentioned. Others have done so. History have, however, shown that they were correct to do so, and those laws are fortunately not with us and should never be with us again.
So you chose the wrong side of history. And it's now catching up with you. You see? It's of your own making.
Commissioner, the history is what we had and what we dealt with. How we deal with the future is in our hands.
Now, you were asked about the language. I'm trying to be moderate, you see. You were asked
I
about
think you are now, Commissioner. So you can.
You were asked about the language. And I want to just briefly canvass that point. Which African language can you speak?
Can't speak any African language. I can at least greet people in isiZulu, in Sepedi, in Setswana, and I can ask how they are. I can do very little other than that.
Can you greet me in Sepedi?
Dumela, Commissioner Malema. That guy?
Oh, okay. Now, why are you having a difficulty knowing our African languages?
Why do I have a difficulty? I'm working on the difficulty. I have language courses, but I don't know why they don't come readily to me, perhaps because of the diversity and because one doesn't sit with a specific language for a period of time.
No, just one. I don't mean all of them, just one. I will be very comfortable if you were to say to me, I can at least speak one African language 22 years into democracy. You still can't express yourself in any African language. Is it because it's inferior? It's not important to you?
Commissioner Malema, and which one in Pretoria should I choose? Of all those other colleagues or the practitioners or those in Pretoria?
No, I said any African language. The choice is yours. Why are you not even knowing one African language? In Pretoria, the dominant languages there is Pedi, Tswana. At least one. Have you taken classes?
Yes, and I am working on it, but I can't give you an answer why now I can't speak any African language fluently. It is perhaps because the practitioners or those I deal with are perhaps better than me in that they speak then English, or in Pretoria, an Afrikaans.
Now, what is racism?
I'll have to think of an own definition now. To my mind, it is any way of thinking, of acting towards any other person based solely on his color, culture, or background. And if that is what defines how you act towards him, then you are being racist.
What is white supremacist?
Commissioner, I think it means different things in different contexts, but supremacy will then be when any group of society racially constitutes exercises power over any other part of society purely because of their color or race.
Not
And it can be
knowing,
white or black or
not knowing our African languages doesn't border on on white supremacy.
no, with respect, not, Commissioner.
You don't think you're so superior that you don't even have to learn our languages because they are so inferior and not important.
No, Commissioner, not at all.
So if they are not that inferior and less important, why do you know Afrikaans and English and not African languages? Because the people you are going to serve there, majority of them are those Africans. Many of whom, particularly in the criminal cases, can't even express themselves in Afrikaans or English. And there is an interpreter, I know that's going to be your response. Sometimes the interpretation gets lost. You are given a wrong interpretation and you make your judgment based on a wrong interpretation. Where is justice there? If indeed you have considered all of this and your reason is not because of white supremacists, then why didn't you take effort to know our languages?
Commissioner, it is so that interpreters make errors, and I've heard them translate incorrectly. And we all know that sometimes in a criminal matter, for example, the accused answers a question with a whole paragraph, and all that the interpreter says, he says yes, and then one knows it's wrong, and then one should explore that. But I've never had, I repeat that with the practitioners and the system of interpreters, there's sufficient assistance to follow the proceedings. And I hear what you say, but what if there is a fault, or what if the interpreter interprets incorrectly? But Mr. Commissioner, the same will apply. What if it's a person of a smaller language, Sivenda, and the judge is Zulu and he knows nothing of Venda, then the same can happen with respect.
After this discussion, do you see any need to double your effort in knowing African languages?
Yes, of course.
Thank you.
Prof.
Thank you very much, CJ. Good morning, Advocate.
Good morning, Commissioner.
Just have two questions because many of them have been canvassed already. In your section 4 under general, you made reference to the Constitution as an act of 108. Should we be very concerned about the reference to the Constitution as an act? Because as an academic, I'm concerned about how and what I write. And secondly, on page 5, under section 5, you made reference to the publications outside the field of law, where you answered by responding to various presentations that you have made. What is the distinction between a publication and a presentation? Thanks.
If I might answer the first question quickly. I was here at an interview before this commission last year and asked about the Constitution. I think I gave a very short answer, but it's still the same. And that is, to me, law is actually easy, or the application of law is actually easy because you have the yardstick of the Constitution to measure it against, whether it's the application thereof or the conduct complained of or the dispute before the judicial officer. On the second question of publication, a publication I understood to mean a written publication in a widely disseminated journal, such as academic publications often are, the de jure, the de rebus, or other academic publications in a specific field of law, be it intellectual property or labor law and the like. A presentation is a PowerPoint presentation, and although there is a hard copy, it is to a more limited audience. It is not of wider publication accessible to all.
In respect to your first response on the Constitution, should we be very concerned that we are going to lose the cases on a technicality because the Constitution had long been amended. It's no longer referred to as an Act number 108. It is a Constitution 1996. Because if we are going to lose the cases on a technicality, so it means that the quality of access to justice will be compromised.
Now, one would be presumptuous to say that there can never be errors or even administrative errors. One must, however, always consider properly before you render a judgment. And any judgment should be such that it should not be incorrect because of a technicality. Technicalities of the nature of an error or a typographical error or a patent error are easily corrected in terms of Rule 42. Other issues or decisions, I think my judgments speak for themselves, have been reasoned and researched, and they haven't been flawed due to technicalities or for technical reasons. I do not think, Commissioner, that there should be that fear. If I have at least rendered 112 judgments, I am aware of once where I was overruled on appeal, but again, one should not say, well, I can never be wrong and never be overruled, because everyone can, and that's why there is a procedure for leave to appeal. But generally, I think there's not a fear of the nature that you mentioned.
The second response, a presentation is not a publication. I'm concerned because I'm an academic. A presentation is not a publication, because a publication, if we define it broadly, it means that it is something that is there for public consumption. Because if you come and present a particular topic on this commission, it is limited here.
Yes.
It's not going to be archived for the future, as it happens with what we write in the academia, with what you write as well in your judgments. Thank you.
Commissioner, Chief Justice, I'm not sure whether I should respond to that comment. Thank you, Commissioner.
Commissioner Semenya.
Chief Justice, thank you. Advocate Davis, good morning.
Good morning, Commissioner.
Constitutional litigation in the main probes state action. If a general statement can be made, how is your impression? How have the state parties been faring in this area?
As a general observation, Commissioner, if one has regard to the press, it seems that the state has not necessarily been faring very well. If one has regard, however, to law reports, then each and every instance where the state, before I carry on with that answer, one should always be aware of the separation of those who make the laws, the legislature, those who execute the laws and govern, the government, and I understand that's where the state comes in your question, and the judiciary. And the judiciary should apply the law and test the actions or the legislation against the Constitution. If the state does not, to use the words, fare very well, then that is part of the corrective measure which the judiciary then exercises as that arm of government. It does not necessarily, on the general perception that the state might not be faring well, be a bad thing. It might just be that the judiciary, as corrective measure, is operating well.
Your general impression, how has state parties been doing, from a bench or as a practitioner?
It does appear that the state does not fare very well. But having said that, in each and every instance, one must not have that perception in your mind. That is why I referred to the law reports. If one has got to the law reports, there's a fair consideration of each and every instance, be it a transgression or a testing of a state exercise of power.
No, I accept that judgments must be what they are, fair to the issues and correct on law. What would you say are constraints on judicial power constitutionally?
Well, the separation is not a constraint, but is a ring fencing of the exercise of judicial power. If an act, for example, is unconstitutional, a court should then decide whether it's a whole act or only a section. And if there is a section which is unconstitutional, the court should then not make the law, but then give Parliament the opportunity to correct the law. So the court should not stray across the boundary into the realm of the executive or the legislature.
And you'd accept as correct that judges can do no more than what the Constitution authorizes them to do?
That is so, but if there is, for example, a striking down of a section as being unconstitutional, the Constitution also empowers the judges then, particularly in that matter before them, to grant appropriate relief. The Inyati matter was an example where the relief was granted to Inyati, but the other corrective measures as to how and when execution should be levied against the state was left untouched in my judgment for the realm of the legislature, and similarly the Constitutional Court did the same and granted the state at least 2 extensions to amend the act.
Yes, judges strike down executive, legislative, or any other action as inconsistent with the Constitution because the Constitution authorizes them to do so. Am I right?
With respect, Commissioner, it doesn't authorize a judge to do so, it obliges a judge to do so.
Oh, okay, let's use your terminology, obliges them to do so. Why do you want to become a judge?
I've wondered about this question myself since the previous interview, and no, nothing about the questions, Commissioners. But there comes a time in your practice where you must consider that if you remain in law and passionate about law and justice as you then are, whether it is sufficient to continue a career only as a sole practitioner, which primarily then is for your own account, or whether you can do more and should do more and participate in the administration of justice, which goes broader than yourself.
Advocate Davis, thank you. Chief Justice, thank you.
Thank you, Commissioner Semenya. Minister?
Thank you, Chief Justice. Advocate Davis, you touched on the issue of transformation of the profession and in particular the role of the state attorney. I thought it would be remiss of me not to canvass further, given the interventions that you have apparently made to try and improve the situation. Well, let me start by acknowledging that indeed I personally have had that impression from a practical experience that there are challenges in the capacity and efficiency of the State Attorney's Office. One of the challenges that I want you to address me on is the right of a client to choose who should represent them in the context of the role of the State Attorney. If a government department, if a particular executive functionary believes that a particular practitioner is best placed to maximize the prospects of success in litigation, and therefore insists that they would want to be represented by X, given the fact that certain practitioners have their reputation preceding them, whether justifiably or otherwise, how do you feel the state attorney should respond? What should be the policy of government, rather, let me put it that way, because I'm asking this question because we are in the process indeed of reviewing the policy governing state litigation, and we can benefit from the experiences of practitioners in this regard. Should we adopt a policy as government that is imposing on client departments as to how the selection of representatives for them should be done? Or should we leave it to the discretion of the client themselves?
Minister, I'm not exactly sure how this impacts on my ability to sit on the bench, but if I might make the following observations. Firstly, your name...
You are entitled to say if you feel the question is unfair on you, but it's not intended to really judge.
Firstly, Minister, your name tag in front of you is misleading. And I was surprised. And secondly, Minister, I'll be as brief as possible. Yes, a client should be entitled to choose the counsel, to have his attorney brief a counsel, which would maximize his success. But certainly a client is entitled, as his access to justice rights, to have his attorney brief a counsel of his choice to maximize his chances of success. However, that is not the general perception of how the state departments as clients and the state attorney works. Often matters are of a generic nature, which means that there are a number of counsel, and then in particular counsel of colour and female counsel who can equally do the job of the counsel currently briefed by the state attorney for that department. And often, if it's not of a generic matter, there is insufficient consideration in our perception of those state clients in considering alternate counsel to those who they've been used to briefing, which leads then to skewed briefing patterns, and those skewed briefing patterns we perceive are continuing by the state attorney despite having been pointed out and despite the reports on the briefing patterns. I know there are statistics which say otherwise, but if one has regard to what appears in court, our perception is still that a state department does not go and sit and say, you know what, must I brief white counsel A, or is there a equally competent black counsel, or what about a lady barrister female counsel? State departments don't do that. They just say, I want X and I've always used X and I couldn't care less what you, the state attorney, or anyone else says. That is not a proper exercise of a preference of a counsel to maximize a result, particularly not in our transformative requirement society.
The second question, I must say my limited experience is that there's a bit of both, but be it as it may. My second question relates to the contribution that the organized profession can make in promoting transformation in this regard. Are there any, and I'm addressing you as a member of the profession and of a particular professional body, are there any specific interventions or proposals that as professional bodies you can make to the state, given the fact that you are more privy on a day-to-day basis of what actually transpires in practice, that you would want to suggest to the state as to a better way of monitoring and enforcing inclusivity in briefing patterns and related matters?
Well, Minister, firstly, your question is from the state point of view, but from the profession's point of view and transformation point of view, it should not only be limited to the state, it should be limited to all institutional bodies, not only state and NGOs, but also big corporate institutions. It's difficult for advocates to enforce that, or it's actually impossible to enforce, but it is hopefully possible to influence, because we are a referral profession, and the attorneys then refer the briefs. But if, for example, it could be that every large institution, or every banking institution, or every state department, when it briefs counsel, says to its attorney, the state attorney or the private attorney, when you brief counsel on generic matters, where there is not a real difference on who the counsel is and anyone can move an unopposed application, at least confirm to me that you've done the following. You've taken race and gender into consideration, and your end result relates quantitatively to a transformation of a briefing pattern. Secondly, if it is then anything contentious.
Sorry, just to clarify my question, I'm specifically asking the question as to whether you see any responsibility on the part of professional bodies to make an intervention.
Yes, I believe.
And if so, how do you see that occurring in order to influence
yes, I see
a change in that situation?
I see the responsibility on professional bodies, and I see the responsibility, for example, if not the General Counsel of the Bar, then each Bar Council to promote the transformation to the benefit of its own members. And if that means meeting with the state attorney or meeting with deputy directors general of different departments to in direct contact with them, convince them that their current practices are insufficient in transformation measures, then that is what must be done.
And just my last question relates to the regulation of silk or acquisition of silk stages. Do you believe the profession should self-regulate when it comes to setting norms and standards as to promotion in terms of ranking, or do you believe that the state should be responsible for setting norms and standards that should determine who rises to silk, for example? And I'm asking this question just to give context in the light of concerns that have been raised that in practice there appears to be a bias based on race and gender that continues to prevail in this regard within the profession itself.
At the Pretoria Bar, if there is a bias, it's a bias in favor of African practitioners and female practitioners. If there is a bias, and our protocol is open to scrutiny, and we've circulated it to your department and to other bars as well to follow. The difficulty is, the perception is, unfortunately, if one were to in a year consider having regard to the ratio between seniors and juniors, say recommending 5 silks to the judge president, and of the 10 who apply, there's only 1 black applicant, then it makes it difficult to make the end list representative. But I think there are sufficient checks and balances in the way to the judge president and the minister that those who know the practitioners better should be allowed to self-regulate unless there is in that self-regulation a skewedness or bias. It is much of a peer review system, and in my composition of the Silk Committee, of course, the race and gender in the peers who review the others are already catered for. And that peer review is something which the state can unfortunately not do, because the state is not close enough to the fire or the battle to see which are the best warriors, if I might use that analogy.
Maybe the very last question that I want to ask is, in your opinion and based on your experience, do you believe that the professions, you could stick to the bar if you feel that the side bar is out of bounds for you, unless you want to venture into that as well, do you believe that the profession has created a sufficient, welcoming, supportive environment for young graduates of who are non-white, if you like, if there's such a term, as well as females in particular, to find the profession welcoming enough to come in their large numbers so that we can begin to see a pool emerging from which we can then produce silks as well as even elevate people to judgeship.
Minister, the first part of my answer would be not yet, because sufficiently means that one has already achieved a goal. We are not there yet, and it is a road and a work in progress. But the second question is, yes, the pool is not only growing, but is already sufficient to meet in the needs of the state, for example, if there is a need for briefs. It is increasingly done so. The General Council of the Bar has, at a general meeting last week, already increased the bursary amount for new pupils. I can't recall the number it stands now at, but it is increasingly increasing. The bars exempt the junior members from first year to third to fifth year of bar fees to encourage them to establish a practice and thereby remain in the bar and increase the pool of juniors, of particularly then African and female practitioners. So the answer is there is a pool. It is there to be utilized sufficiently so, but the short answer is sufficient as an end goal, no, not yet.
Thank you, Minister. Commissioner Singh. Commissioner Modise.
Thank you, CJ. Good morning, sir.
Good morning, Commissioner. It's Davis, Commissioner.
Good
morning, Commissioner.
It is still sir in my culture.
I just didn't want us to venture into the territory of Mr. Adams again.
No, that's fine. Earlier in your response, you referred to writing on behalf of your colleagues. And I am just curious as to whether you have any view on judicial dissent and whether you think dissenting has any place, negative or positive, to the development of our jurisprudence.
Sorry, Commissioner, what was that last word?
Whether, in your view,
Yes.
dissenting has any positive or negative impact on the development of our jurisprudence.
Like writing a dissenting
judgments.
Thank you, Commissioner. Yes, of course it has.
And thank you, CJ.
Thank you, CJ. Commissioner, of course it has a place. In the most recent law reports of September, there was a decision of the Constitutional Court reported, and I think that the Chief Justice gave the judgment, and there were two dissenting judgments. The dissent then sometimes is a general dissent to say, no, I would not have allowed the appeal, and sometimes the dissent is, yes, I would also have allowed the appeal, but for the following reason, or this is something which can or should be added. So a dissenting judgment is not necessarily saying the principal judgment is incorrect, but can actually add to the value of the principal judgment by either adding another ground or another string to that bow firing the judgment or giving the order, or it can even then assist in showing, yes, although there is a different opinion, and although one of the parties might have had it, the principal judgment is the correct one. So yes, I, as a general proposition, agree that a dissenting judgment or dissenting judgments can contribute to jurisprudence.
So the first one was, have you ever?
Given a dissenting judgment?
Yes.
Yes.
Commissioner Schmidt.
Thank you, Chief Justice. Advocate Davis, well, the initial impression at least that you lacked experience in the criminal law field seems to be at least partially created by your own questionnaire, where it indicates 0%, your practice consists of 0% in criminal law field. It sits at odds with your reply that you've appeared at least 13 cases in the ECA.
I noted that last night again, and that should be a reflection of the current composition of my practice.
Then secondly, your LLM, which law field was it conducted, field of law?
In criminal law and procedure.
And you indicated that there was one judgment where one judgment where you were overturned on appeal.
Yes.
Of all 112 judgments.
Yes, of which I know. And the judgment that I was overturned on has been included in the first one in the Mundell. It's the one of MBD securitization. On the general principles of law, there was no overturning. It was just that the full bench in our division found that on the applicants, or it was the respondent's version of not having had knowledge of the service of the summons, he should have been found to have been correct, and therefore judgment shouldn't have been granted against him.
Thank you, Chief Justice.
Thank you, Commissioner. You're excused, Mr. Davis.
Thank you, Chief Justice. Thank you, Commissioners.